Good morning to all those on the line. My name is Scott Sweatman. I'm a partner in the Vancouver office in the Employment and Labor Department, Pensions, Benefits, and Executive Compensation. I am the moderator for this morning's session. A couple of introductory remarks before we get underway. For those clients of ours who do not yet have the toolkit, they can call their local employment lawyer they usually deal with and get a copy of that email, and we'll send them to you. So let us know if you don't have the toolkit. You can also go online for additional, quite substantive material, both on a national and global level, for our global tracker and ongoing provincial updates from yesterday and today. As we all know, it's a moving target. A couple other introductory remarks. For those seeking accreditation for these sessions, please note that this session is eligible for one substantive hour with the Law Society of Ontario and the Law Society of British Columbia. We have submitted an application for eligibility for the Quebec Society, which is pending. You'll get information on that after the webinar with a recording of the webinar as well and the presentation materials. So you will receive that shortly. Also note in that respect that the presentation is not available for download by the attendees via WebEx, so you'll receive it by email on Monday with the recording. With that introduction, the other issue, this is we've not used WebEx on this prior to this seminar. This is our fourth webinar in this series, in this challenging series we're all facing. But the Q&A, if you can just enter your questions in the Q&A section on your screen, these answers will be dealt with subsequently, much like we're going to do with last week's questions at the end of this seminar. So without going much further, given the time, we have an hour, I want to introduce our speakers. Jeff Bastian is going to speak on the CREB update that we've been receiving. He's going to be up first. He's from our Vancouver office, senior associate. Next up will be Gergely Higadus, who is a associate in our tax department in our Edmonton office, and he will be dealing with the wage subsidy specifics, again, such as they are. As we all know, this is a moving target. Followed by Gergely will be Stephanie Lewis from our Edmonton office, and she's going to be dealing with Alberta, BC, and Ontario layoff issues. Followed by that will be Ariane Bouchard, who's speaking in place of my partner Virginie Dentons in our Montreal office, who couldn't make the presentation, so we're in good hands with Ariane. And followed, last but not least, is Alison Walsh, who will be speaking on EI options. With that, I'm going to turn the presentation over to Jeff from our Vancouver office. Jeff? Jeff, are you on the line? Jeff Bastian, Senior Associate, speaking from Vancouver on the Canada Emergency Response Benefit update.
Yeah, I think that's the issue. So funny enough, Francis, I just ran it from my documents, and it worked. Yeah, so it worked. Download. Hello, can you hear me now?
Yes, hello. Was anyone ever able to hear that introduction? I apologize. I thought I was gone. I was live.
Introduction was heard. Jeff, you can start yours presentation.
Can't hear you, Jeff. Just one, I apologize for the technical difficulties. Jeff is calling back in. Please stand by. We're still not hearing you, Jeff. Jeff, are you on now? I apologize for the technical problems. We'll get them resolved.
Scott, let's move on to the next speaker and we'll come back to Jeff.
All right. We're going to move on to Gergely Hegedus from our Edmonton office. I'm just going to advance the slides. Our apologies.
Thanks, Scott. I'll just wait till you have the slides up.
Yeah, they're coming. Over to you, Gergely.
Thanks, Scott. Hi, my name is Gergely Hegedus. I'm a senior associate in the Edmonton office of Dentons' tax law group, and I'll be talking about the Canada Emergency Wage Subsidy today. I'll start by giving an overview of what the subsidy is. I'll talk about who qualifies and who doesn't. I'll talk about how you qualify, how you apply, how it's paid, and whether it's taxable. So to start with, what it is. And so it's a source of income through this difficult time caused by the pandemic. And the intention is to allow employers to rehire workers that were previously laid off and to keep those who are already on payroll. Just previous to this presentation, one of the attendees had a question about whether employers had to that their employees would be working. And at this point, it doesn't seem like there's any requirement that employers have to guarantee that their employees will actually be working during this period. But more details are due to be announced in the near future. So I'll talk about what the amount of the subsidy is, and it's based on an annual salary of $58,700 per employee. So that's not the actual amount that the employer will receive, but it's the basis of how it's calculated. So if you take $58,700 and divide that by 52 weeks of the year, that'll come to $1,128.84. And so employers are entitled to 75% of that, which is $847. So the maximum entitlement per employer or per employee per week is $847. And that's for up to 3 months, and that's retroactive back to March 15th, 2020. So who qualifies? Employers of all sizes and across all sectors of the economy qualify for this. So this includes individuals, taxable corporations, partnerships consisting of eligible employers, nonprofit organizations, and registered charities. Who doesn't qualify? Public bodies don't qualify, and that includes municipalities and local governments, crown corporations, public universities, colleges, schools, and hospitals. How does each employer qualify? Well, they have to have a drop in gross revenues of at least 30% in the 3 months where the subsidy is applicable. So that's for March, April, or May, compared to the same period of last year. And employers need to attest that they've had a decline in revenue when they apply. So what period do you look at to qualify? You look at, for the claim period of March 15th to April 11th, you look at the same calendar, the month for the same in the previous year. So for March 2020, you'll look at March 2019, and the same is true for May and June. We've got some guidance on what revenue is. And so revenue is business carried on in Canada, earned from arm's length sources. So what seems to be excluded is foreign sources of income and non-arm's length sources. It also excludes revenues from extraordinary items on accounts of capital. And extraordinary items will include items that are not typically reoccurring in the natural course of business. And this would include amounts such as, say, a business has property that's expropriated, that would be included as an extraordinary item that would not be included in revenue. Move on to the next slide, Scott. So what about nonprofits and charities? Well, the government's working on guidance as to how nonprofits and charities qualify because obviously they don't fall under the typical criteria for businesses. So we expect to see some guidance on that in the near future. And many businesses are probably wondering if the amount is taxable, and the answer is yes. It's considered government assistance and will be included in the employer's taxable income, and it will also reduce the amount of remuneration expenses eligible for other federal tax credits calculated on the same remuneration. And many of you are probably wondering about non-arm's length employees. So this would include, for example, someone who's employed by a professional corporation that they're the owner of. So the subsidy does arm's length employees. However, the criteria is different. So it's limited to the eligible remuneration paid in any pay period between March 15th and June 6th, 2020, up to a maximum benefit of $847 per week, or 75% of the employee's pre-crisis weekly remuneration. So this is likely in effect so that it's only applicable to those employees who are employed by non-arm's length employers prior to the March 15th pandemic. So is there a limit to how much eligible employers can claim? And the answer is no. The overall limit depends on how many employees an employer has. So the more employees that an employer has, the more subsidy they'll be entitled to. So how does one apply? Well, there seems to be two ways that businesses will be able to apply. One will be through the CRA's My Business Account portal, and the other one will be through the web-based application, which hasn't been revealed yet. And questions have been asked to whether the employers have to top up the remaining 25%, and the answer is no, but the government has stated that employers are expected to make best efforts to top up. However, there's been no information released as to what best efforts are. So how long will the program be in place? It'll be in place for a 12-week period from March 15th to June 6th, 2020. However, given the nature of the pandemic, I think there's a good chance it could be extended even longer. So when are we expecting to see the program roll out? It'll take about 3 to 6 weeks according to government, and 6 weeks being the worst case scenario. So hopefully in the next 3 weeks, we should see some movement on this. So I just have a quick example that's been provided by the government. So we have a business which has 4 full-time employees that each earn $800 a week, and also 6 part-time employees earning $400 a week. So prior to the crisis, the total weekly payroll was $5,600, and yet revenues have decreased for the business by 30%. So that means that they're eligible for the subsidy, and they'll receive a subsidy of $4,200, which is effectively 75% of the pre-crisis wages. So questions have been asked as to what happens if you receive the subsidy and you're not entitled. Well, obviously you'll be expected to repay the subsidy, but there's also likely going to be penalties for fraudulent claims. The government has indicated that it might come out with anti-abuse rules, and there are likely going to be new offenses, and penalties may include fines or even imprisonment. So what you might be wondering what the interaction between the subsidy and the Canadian Emergency Response Benefit will be. So if an employee is receiving the Canada Emergency Response Benefit, then the employer will not be eligible to claim the subsidy in respect of that employee for that period. And the 10% temporary wage subsidy is still in place. So organizations that don't qualify for the Canada Emergency Wage Subsidy, that is, if they don't have a reduction of 30% in revenues, they may continue to qualify for the 10% wage subsidy. And that was in place for small and medium businesses. And so it's up to a maximum subsidy of $1,375 per employee and up to $25,000 per employer. So there might be some organizations that qualify for both the 10% wage subsidy and the 75% subsidy. So government's indicated that if the organizations claim the 10% wage subsidy and they're eligible for the 75%, then the emergency wage subsidy will be reduced by the amount of the 10% subsidy they receive.
Thank you very much, Gergely. I think if Jeff's back on, we'll go back and reorder ourselves as planned. Jeff, are you on?
Yes, hopefully you can hear me now, Scott.
Yeah, I'm going to go back.
Perfect.
And again, sorry for the technical challenges. We're lawyers, not technical people.
So I apologize for that, but now that you can hear me, I'll start talking about the Canada Emergency Response Benefit. I'll refer to it in short as CERB, so you know what I'm talking about. That's what I mean by CERB. And so what this does is it replaces previously announced emergency care benefit and the emergency support benefit. So it's intended to be a temporary income support that's simpler and more accessible than what was previously announced. And what it is it's 4 lump sum payments of $2,000 every 4 weeks for up to 16 weeks. And this is intended to be broader in scope in terms of who is eligible for it. So it's not limited strictly to employees. It is also available to other types of wage earners. So that would include independent contractors or self-employed individuals. The current period for the CERB is from March 15th, so it's retroactive to March 15th. Through to October 3rd, 2020. And applications can be made up until December 2nd. So it's possible to retroactively apply if somebody's in hospital or unable to apply at the time. In terms of eligibility, applicants have to reside in Canada and be at least 15 years old. And then have either stopped working because of COVID-19 or they're eligible for EI, regular or sickness benefits. Examples of having stopped working because of COVID-19 that have been provided are where somebody's been terminated or laid off, their hours have been reduced to 0. If they're quarantined or sick due to COVID-19, it would include people that are away from work to take care of others because they're quarantined or sick. As a result of COVID-19, or even individuals who have to be away from work to care for children or other dependents whose care facility or schools are closed due to COVID-19. One thing to note is you can't quit your job voluntarily and claim the benefits. So this probably raises the question of whether somebody who refuses to work on the basis that they think it's unsafe is able to claim the CERB, and that's not entirely clear at this point, but they can certainly apply for the CERB. From an employer's perspective, though, you do want to make sure, as we've talked about in previous webinars, that you're making sure that you're taking care from an occupational health and safety perspective to understand their concerns about what they feel to be unsafe, and that you're addressing those concerns. You can demonstrate reasonable steps to be taken to address those concerns. The other parts of the eligibility include having had income of at least $5,000 in 2019 or the last 12 months, and that would include income from things like employment, self-employment, maternity or parental EI benefits, or similar benefits paid in Quebec under the Quebec Parental Insurance Plan. One other thing to note is that the CREB is premised on being without employment income. Therefore, you can't use the CREB to supplement income for employees that just have reduced hours. It is based on not having employment income. With respect to the interplay between the CREB and EI benefits, individuals are not eligible to receive both for the same period of time. So the way it's going to work is the March 15th date for the CERB is sort of a benchmark. And so individuals that were already receiving EI regular benefits before that date will continue to receive those benefits until the end of the benefit period. And if that happens to be before the end of the CREB period, October 3rd, 2020, then they can apply for the CREB. If the person became eligible for EI benefits after or on March 15th, then the claim's just automatically going to be processed through the CREB. And what this means is that when somebody is eligible for the CREB, they'll receive that $500 per week, or essentially the $2,000 every 4 weeks. And that's regardless of what they would have made or would have received through EI. So if they would have received a higher amount through EI, they still get the $2,000 per 4-week period through the CREB, even if they would have received more through EI, and vice versa. If somebody would have received less, they still get the $2,000 per 4-week period. Last note there is that individuals do retain the eligibility to receive EI after they stop receiving the CREB. So applications for the CREB will open up on Monday, April 6th. Prior to this, people are still able to apply for EI if they're eligible, and that will be processed either as an EI claim or for the CREB, depending on that March 15th date and when the individual became eligible. On or after Monday, applications can be made through the CRA, and there's a single portal that will be used for applications for the CREB and EI, and that can be done either online or by phone. And anticipating the surge of applications, the CRA has encouraged people to apply on certain days based on their month of birth, and that's available online to see when they recommend people apply. And then lastly, 2 notes here on the next slide, is that people apply for the CREB every 4 weeks. So if they are eligible for the first installment, they do need to reapply to confirm their eligibility going forward for the next period. And assuming everything goes according to plan, the government has indicated that direct deposit should be expected within 3 business days or by check within 10 business days. And with that, I'll turn it over to the next speaker, which is, sorry, I don't know who's not after Gergely.
Thank you, Jeff. I'm just racing ahead to the next series of slides. Next up is Stephanie Lewis, who's counsel in our Ottawa office, and she's going to address layoffs in Alberta, British Columbia, and Ontario. Stephanie?
Thank you very much, Scott. I'll just take this opportunity to welcome everyone. Those of you joining us from out west, good morning, and those of us from Ontario or further east, good afternoon. Given what's happening with COVID-19, it no longer makes financial sense for many businesses to maintain the size of their current workforces. So we're getting a lot of calls about temporary layoffs. Generally speaking, temporary layoffs are periods when employers temporarily stop providing their employees with work and compensation. There will be situations where employers will be continuing pay but at a reduced rate. That may also, depending on your jurisdiction, meet the definition of temporary layoff. For example, in British Columbia, a week of layoff is a week when there is a reduction of 50% or more of an employee's regular weekly wages averaged over the previous 8 weeks. So if you're engaging in salary reduction, it may nevertheless be a temporary layoff, and you'll want to reach out to your friendly neighborhood Dentons employment and labor law team member. There is a maximum length for temporary layoffs that varies from province to province. And a point of discussion that we've been having quite heavily with many employers is that temporary layoffs are not permitted at common law. This means in order to safely engage in a temporary layoff, you need to include a clause in an employment contract. If it's not included in the employment agreement, you can nevertheless proceed with a temporary layoff. It just means that employees can claim constructive dismissal. So on that note, we've had a fair amount of discussion about the fact that just because someone who can claim constructive dismissal doesn't make it illegal to enter into temporary layoff. It just means that at the end of the day, a company may be responsible to provide pay in lieu of notice to the employee as if the employee has been terminated. When it comes to companies trying to survive this, sometimes it's best to take imperfect options to try and preserve companies and jobs. So now we'll move on to what the maximum length of temporary layoffs is, depending on jurisdiction. In Ontario, there are two potential maximum lengths. If you're not going to pay anything, then the maximum length is up to 13 weeks in any period of 20 consecutive weeks. That is also the maximum length in BC. However, in Ontario, there's another possible maximum length if the employer is able to continue benefits or pension plan payments during the temporary layoff. The length of the layoff can be as long as 35 weeks in any period of 52 consecutive weeks. And in Alberta, the maximum length is 60 days in any 120-day period. The question is, what happens in the event that the maximum length is exceeded? And in those circumstances, an employee will be deemed to have been terminated. It's considered to be, their employment is considered to be at an end, and the employer must pay termination pay as well as any outstanding vacation pay. And the date of termination in that circumstance is the first day of the layoff period. So the next question is whether or not advance notice is required. So Scott, if you want to flip to the next slide. The short answer is that in Ontario and BC, the answer is no. Practically speaking, you'll want to give employees a tiny bit of notice just to maintain positive employee relations, but there is no statutory notice requirement. In Alberta, however, an employee is entitled to between 1 and 2 weeks of notice of temporary layoff. If an employee has been working for an employer for less than 2 years, they're entitled to at least 1 week of notice of temporary layoff. And if an employee has been working for that employer for 2 years or more, they're entitled to 2 weeks notice of temporary layoff. However, there are exceptions to this notice rule for unforeseeable circumstances, like the situation that we're in right now. In such circumstances, employers are required to provide as much notice as possible to the employees, even if you can't make the 1 or 2 week notice requirement time. Now you know that you can do it. How do you provide that notice? The notice has to be provided in writing, and it needs to state the layoff is temporary and when it will be effective. In Alberta, the notice also needs to include a copy of sections 62 to 64 of the Employment Standards Code. A record of employment has to be issued on temporary layoffs. So in the best notice letters, you're going to advise the employees that they will be receiving their record of employment, and they can use that to apply for benefits through Service Canada that may be available, like the Canada Emergency Response Benefit that we've heard about from Jeff. The best layoff notices also lay out what employees can expect while on layoff. They will include any benefits that will be continuing. So if you're extending to the 35-week maximum and you're continuing benefits, you'll be mentioning what benefits will be continuing in your letter. So now while on layoff, and I include this information in the notice letters that I prepare, employees are allowed to look for other work. This is not something that employers are probably very concerned about losing employees right now because who's hiring, but I certainly let people know that they can look for other work and that their vacation entitlement continues to accrue. There's an interesting note there, and I explain this in my letter. While the entitlement continues to accrue, vacation pay does not, because vacation pay is calculated based on a percentage of wages, and during temporary layoff, employees aren't receiving any wages. So they are continuing to receive their vacation, but not vacation pay. So we've given people notice. They have been temporarily laid off. What happens when employees are recalled to work? Firstly, you're gonna recall them in writing and let them know the dates they're expected to be back. One of three things is going to happen. If they are recalled to work at any time prior to the end of the temporary layoff period and they come back to work, their employment is going to continue as if the temporary layoff never happened. So there's no break in service for the purpose of calculating vacation entitlements or subsequent termination entitlements. If an employee is recalled to work at any time prior to the end of the temporary layoff period, they're required to attend work on the stated date. If they don't return to work, they're deemed to have resigned, and employers aren't required to provide them with notice of termination or severance. Finally, if employees aren't recalled to work during the temporary layoff period, they're deemed to have been terminated, which we've already addressed. So on that note, we're going to move to some general tips. The key to maintaining good relations here is to provide timely and transparent communications with your employees about their layoff. You're going to want to let them know recall dates, if there are any extensions, and in order to do this, you're going to want to maintain an up-to-date contact list for employees. And with that, I'm going to hand it over to Ariane Bouchard in our Montreal office to explain temporary layoff considerations in Quebec. Over to you, Ariane.
Ariane, are you on?
Can you hear me?
Yes, we can. Thank you, Ariane.
Okay.
Please proceed.
Okay, sorry. I was just saying that a lot of things that Stephanie mentioned also apply to Quebec. Layoff in Quebec, obviously, like the general tips, for example. This would all be relevant to Quebec, but I'll just add a few more details with respect to what is provided by the Act respecting labor standard with respect to layoff. So during time of economic hardship, it is a common practice for employers to lay off employees. This is not something rare. In Quebec and everywhere else, a layoff temporarily suspends the contract of employment between the employer and the employee. So this is not a permanent decision. Employees maintain their employment relationship and contractual relationship with the employer during that period. So, for example, a non-restrictive clause would continue to apply despite it does not preclude the employee to look for other employment, for example, but restrictive covenant will continue to apply. And in Quebec, according to the Act respecting labor standard, a layoff is a temporary layoff if it is less than 6 months. Unlike in other provinces, this is not like 6 months during a certain period. It's really like 6 months. However, if you have like consecutive period of layoff, you will need to be able to explain why you recall the employee between a certain period of time during 2 periods of layoff. So these 2 periods are not considered as the same period. With respect to the obligation of the employer during temporary layoff, there are no advance statutory notice requirements before an employee can be placed on temporary layoff. A written notice is not mandatory, but it is highly recommended to document it and document with all the condition and specification of the layoff. Severance and termination payment are not out to the employer. To the employee, if the employer recalls the employee before the maximum time frame for a temporary layoff, so 6 months. And in the case where the layoff is for an indeterminate period, the employer only needs to pay the notice indemnity at the end of the 6th month. An employer is not required to pay the vacation indemnity at the time of the layoff unless the employee's vacation was planned during this period, and there's no obligation to do so, but an employer and an employee can always agree that the employer would pay this vacation pay to try to help the employee during that period of hardship. If an employee is not recalled before the maximum deadline, they are considered permanently laid off or terminated, and they will be eligible for all the same entitlement that they would have in a case of termination. So payment of all accrued wage, payment of any accrued overtime, payment of the vacation bank, termination indemnity, etc. With respect to the income and benefits during layoff, in most cases, employers are not required to continue benefits or pension plan contribution during the temporary layoff, but it will always depend on the specific contract, so you want to review it at that time. With respect to the group insurance coverage, it is to determine whether it is continued or suspended. It's really at the employer's discretion. So it should be noted that most employers only suspend the coverage for disability benefits during this period, and they would continue the coverage for dental, medical, and other type of coverage. Employee contribution to retirement and pension plan, as well as employer matching program, are also generally suspended during this period, but some employee may want to continue to contribute to their plan, so you can give them that option. And finally, subject to an employment agreement, a policy or a collective agreement that say otherwise, layoff periods are generally unpaid. Finally, as mentioned by my colleague, employee may qualify for EI or the CREB during the layoff. A record of employment must be issued for each employee that is put on temporary layoff. And when you issue the record of employment, you must enter the code that best corresponds to the reason for which you're issuing this document. In the case of a layoff, most of the time it would be the code A, so shortage of work, that must be included. Finally, all that I said was applying to non-unionized workforce. With respect to unionized workforce, what is very important is to review the layoff provision of your collective agreement, because this is those provisions that will determine the parameters of the temporary layoff. And it must be noted that many collective agreements require employee to recall employee once the need for the layoff subsides and within a predetermined period. The right to recall might expire after a certain period of time. In some collective agreement, it can be longer than 6 months. And in those cases, if the employees have a right of recall, you don't need to pay the indemnity, even if it's more than 6 months.
Thank you, Ariane.
You're welcome.
That's very helpful. Moving on to Alison Walsh, who's a partner in our employment and labor practice in our Edmonton office. She's going to take us through the insurance benefit overview. Alison.
Thanks, Scott. Before I get into the details of my presentation, I just wanted to make a quick comment about temporary layoffs in Alberta. So in Alberta, under the Employment Standards Code, the 60-day temporary layoff period can be extended if the employee agrees to the extension and if the employer continues benefit payments or pays the employee's wages or an amount instead of wages during the layoff period. So in Alberta, it is also possible to extend that temporary layoff period beyond the 60-day period if you continue to provide some type of payment to the employee in compensation of the layoff not being a finite period, and the employee also has to agree to that. So moving on to my presentation regarding employment insurance benefits, the first program I'm going to discuss is employment insurance regular benefits, which I'm sure most of you are familiar with. So these provide regular EI benefits to individuals who lose their job through no fault of their own. So for example, shortage of work or a mass layoff. The employees have to be available for work and able to work, but can't find a job. The general eligibility criteria is the employee has to be employed in an insurable employment. they have to have been without work and without pay for at least 7 consecutive days in the last 52 days. And they have to have worked the required number of insurable employment hours in the last 52 weeks or since the start of their last EI claim, whatever is shorter. Not everyone is entitled to employment insurance. So if an employee has voluntarily left their job without cause, or if the employee is dismissed for misconduct, they may not be entitled to EI regular benefits. So how much will employees receive on the EI regular benefits? If an employee is eligible for EI regular benefits, and this is also true for the EI sickness benefits that I'm going to discuss as well, prior to March 15, 2020, the claim will be processed under the pre-existing EI rules. So the value of the EI benefit will be based on calculating 55% of the employee's average insurable earnings up to a maximum amount of $573 per week for 2020. And employees can receive the EI regular benefits for a period of 14 weeks up to a maximum of 45 weeks. If these benefits end before October 3rd, 2020, the employee can apply for the Canadian Emergency Response Benefit if they meet those eligibility requirements. And if the employee applies for EI regular benefits on March 15th or later, they will automatically be processed through the Canadian Emergency Response Benefit. So as Jeff already discussed, they will receive the $2,000 for every 4 weeks, regardless of what they would have been entitled to under the EI program. So the second EI option available for employees is the Employment Insurance Sickness Benefit. EI sickness benefits provide up to 15 weeks of income replacement for employees unable to work because of illness, injury, or quarantine. During the COVID-19 crisis, eligible employees claiming EI sickness benefits due to quarantine will not have to provide a medical certificate, and that 1 week waiting period is waived for new claimants so they can be paid for the first week of their claim. If an employee cannot complete their claim for EI sickness benefit due to the quarantine, they may be able to apply later and have their EI claim backdated to cover the period of delay. Again, the value of the EI sickness benefit is calculated the same as the EI regular benefit. So any claims prior to March 15th will be calculated using pre-existing EI rules, and any claims on or later than March 15th will be processed under the Canadian Emergency Response Benefit. And as Jeff already touched on, one of the questions that came up in our last seminar is whether an employee who is quarantining or self-isolating purely based on fear, whether they would be entitled to this. And the answer is, if it's not connected to any prevailing public health recommendations, it's likely that the employee would not be able to qualify for the EI sickness benefits while they're away from work. So the next program I want to discuss is addressing the issue of employment insurance top-ups, and in particular, the Supplementary Unemployment Benefit Plan. Subplans are intended to allow employers to top up EI coverage for employees whose employment is disrupted by temporary shortage of work, training, illness, injury, or quarantine. These subplans have to be registered with Service Canada. If the subplan is not registered with Service Canada, EI top-ups are only permitted for employees on pregnancy leave, parental leave, family medical leave, and critical illness leave. Therefore, before an employer can provide an employee with any top-ups for a temporary shortage of work or stoppage of work, the employer first has to register that subplan with Service Canada. If an employer provides top-up to EI coverage for a non-approved leave, or if they haven't registered their subplan and there's no plan in place, the government can claw back payments from the employee. The Government of Canada has published a sample subplan that can be used by employers as a precedent. Additional documents that employers may need to gather in support of their plan include a copy of a current collective agreement, if that's applicable, company policies and/or insurance policies. Currently, it doesn't appear that the federal government has introduced any changes to relax the registration requirements for subplans in light of COVID-19 at this time. The next program I'd like to discuss is work sharing. Work sharing is another option available to employers in response to COVID-19. Work sharing is a program that's designed to help employers and employees avoid layoffs when there's a temporary reduction in the normal business activity that is beyond the control of the employer. It's a three-party agreement, so it's between employees, employers, and the Government of Canada. The work sharing program provides EI benefits to employees who agree to reduce their normal working hours and share the available work over a specified period of time while their employer is recovering from the downturn in their business. Employees on a work share agreement have to agree to a reduced schedule of work by the same percentage and to agree to share the available work. The key eligibility requirements for implementing a work share program include that the business must be experiencing a recent decline in business activity of at least 10% in sales and or production levels within the last 6 months. And they have to demonstrate that the shortage of work is temporary, it's beyond the business's control, and it's not a cyclical or reoccurring downturn. Employees have to be eligible to receive EI benefits, and there has to be at least 2 employees in a working sharing unit. So a WS unit is a group of employees with similar job duties who agree to reduce their hours of work by the same percentage over a specific period of time and agree to share that work. The unit must reduce its hours by at least 10 to 60%. The reduction can vary from week to week as long as the average reduction over the course of the agreement is from 10 to 60%. Effective March 15th to March 14th, 2021, in response to COVID-19, the Government of Canada has introduced some temporary special measures in respect to its work sharing program. So they've extended the maximum duration of the agreement from 38 weeks to 76 weeks. So the agreement has to be at least 6 weeks long, but they've extended it so it can go up to a maximum of 76 weeks. They've waived the mandatory cooling period off for employers with a recent expired work sharing agreement, which means that eligible employers can immediately enter into a new agreement. And they've also expanded the eligibility to employers who have been in business for only 1 year rather than 2 years. And they've eliminated the burden of having to provide sales and production figures at the same time. Prior to COVID-19, employers applying to participate in the program had to submit their applications to Service Canada a minimum of 30 days prior to the proposed start date. However, Service Canada has indicated that it's streamlining its processing time to 10 calendar days. So they significantly reduced the time in order to be able to put one of these programs in place. Another option is working while on a claim. So Service Canada has EI working while on a claim program that allows employees to keep earning part of their EI benefits and all of their earnings from their job. So working on a claim requires the employee to declare their earnings online. And generally under this program, if an employee earns money while receiving EI benefits, they can keep 50 cents of the benefit for every dollar they earn, up to 90% of their usual weekly earnings. An employee is not eligible to receive EI benefits if they work a full week, regardless of the amount earned. And then lastly, I just want to touch upon records of employment. So if an employee is directly affected by COVID-19 and they're no longer working, an employer must issue a record of employment, and Service Canada has put up on its website the following recommendations for which ROE codes to use. So they've said if an employee is sick or quarantined, you should use code D for illness or injury. If they're no longer working due to shortage of work or because business has closed or decreased operations due to COVID-19, you should use code A, which is shortage of work. And if employees refuse to work is refusing to come into work, but they're not sick or quarantined, you should use either code E for quit or code N for leave of absence. So this brings me to the conclusion of my presentation, and I'd like to pass it back to Scott now to moderate the Q&A portion of the webinar.
Thank you very much. We had lots of questions. I think there were 52 or something, and I see there's lots coming up on my screen, which we will get to, but not today, obviously. What we thought we'd do is try and capture some of the questions, and some of them were similar, of course, so I'm going to pick a few given the time frame, we've got 10 minutes before the close. I think I'll start with one that we haven't touched on today for Stephanie Lewis. It's with respect to essential businesses. The question posed, and there were similar questions like this, does an employer have to be deemed an essential business to need to provide employees and subcontractors a letter? Do they need a letter confirming they work for an essential business in case they are questioned by law enforcement in Ontario? What are the details required for an essential service letter from your employer? Stephanie?
There we are. Just had to unmute. Thanks, Scott. So while it's not specified under the government's order that such letters are required, we strongly recommend them. Anything that can be done right now to support essential employees should be done. We have been hearing stories about people being stopped by the relevant authorities and turned around and sent home. While we can't guarantee that having such a letter will allow the person to pass, reasonable attempts to support are always worthwhile. In terms of the details that I have been providing in letters that I've drafted, you want to include the essential service category that your business falls under, a description of your business to demonstrate that it does in fact fall into this category. You're going to want to let them know the employee's position and explain how the employee contributes to the provision of the essential service. So those tend to be the 4 headings that I cover off in the letters that I've been drafting. Thanks, Scott.
Thank you. I'm going to ask you one more on this one, then I'll jump to another speaker. Again, for you, Stephanie, can a business that's being deemed essential undertake in-person work that is non-essential, or is the entirety of the activities of an essential business deemed to be kosher?
So this is one of those great moments when there is a legal answer and then there's a practical answer. The legal answer is, if you look at the government's order, there is nothing specific precluding operations of all divisions of an essential business. The way the order is worded, it just refers to essential workplaces and not to essential employees. So technically, as long as someone is working for an essential workplace, they can continue to work. However, just because you can do something doesn't mean you should. Practically speaking, unless someone is actually an essential employee in an essential workplace, they should be given the opportunity to work from home, or they should be placed on leave, because we want to be keeping as many people safe as possible and flattening the curve as much as we can. And on that note, any minute now, we're expecting the list of essential businesses to be further reduced by the government. So this may change any minute.
Thank you. I'm going to move on to, again, a different area of this issue we're all facing today, which is for Allison. What are the legal implications, Allison, of postponing a new hire date? Are they eligible for EI?
So regardless of whether the employee has started work or not, if that employee has signed a written contract of employment that includes a set start date, even if the employer's situation has changed and you can't start that employee on that start date, the employee could still potentially have a legal cause of action against the employer for breach of contract. The employee would have the burden of proving the value of any damages sustained as a result of that breach. And depending on the circumstances, the damages can be limited or potentially substantial. It really depends on the particular of the breach. Other issues that may be triggered by delaying a start date include inducement issues, particularly if an employee has left another workplace to join yours expecting to start on that date, and now they don't have a job at all. And also potentially claims for negligent misrepresentation. Whether or not that employee would be eligible for EI would depend on a number of factors, including whether they meet the eligibility requirements for EI, such as having enough insurable hours. However, this might not really be an issue anymore because, as Jeff has discussed, that employee would be likely entitled to the Canadian Emergency Response Benefit. And in such a situation, even if an employee is entitled to these benefits, they would still have a claim for breach of contract, but the fact that they're receiving those benefits might potentially mitigate any risk that such individual is going to, take action against the employer because they do have some income supplement during that period of time. to kind of help tide them over until they officially start work, but it is a risk.
Thank you. I'm going to throw one more at you while we've got an Alberta partner on the line. How much is the payment under the Alberta Emergency Isolation Support? In particular, can the Alberta Emergency Isolation Support be used to bridge the gap until EI benefits are received, as there are significant delays, as we all know, in receipt of EI?
So the payment is a one-time payment of $1,146. Service Alberta has specifically stated on its website that it's a temporary program to bridge the gap until the Canadian Emergency Care Benefit is available in April. So the answer seems to be no, that it's not intended to bridge the gap in EI, and Service Canada on its website in particular is encouraging employers who are eligible for EI to apply immediately. However, again, this probably is a moot point if that claim is for regular EI or sickness EI is made on or after March 15th, because those claims are just going to be directed into the Canadian Emergency Care Benefit Scheme anyway.
Thank you. I'm going to move on to Jeff Bastian from our Vancouver office. Jeff, what happens if an employee is recalled or performs some work during the period of time in which he or she is receiving the CERB payment?
So I guess the short answer is that it's not entirely clear based on the information currently available to us. The eligibility criteria indicates that someone who expects to be without employment income for at least 14 consecutive days in the initial 4-week period, that's that 4-week period starting March 15th, can receive the benefits, and that in the subsequent 4-week periods, they must expect to have no employment income. So it's not clear if there's an obligation to report a change in circumstance or whether there's a possibility that some of the payment would be recovered by the government if that person does end up receiving employment income. So I expect those details will probably become clear in the coming days, but at this point it seems that the goal is just to get money out to the people who need it in a timely manner, but further details I think will probably come in terms of what would happen in that kind of circumstance.
Thank you, Jeff. I think we've got time for one more before we reach our hour. This is for Marianne, or Ariane, I should say. Questions regarding a sub-plan, supplementary unemployment benefit plans. How can we manage planned sub-payments while we're waiting for the sub-approval from CRA?
Yeah. First, I just want to mention that I know that in normal times, like it would take a couple of weeks to get your sub-plan approved. I had some clients that submit some sub-plans since the COVID-19 crisis, and their plan have been approved like within a few days. So it should not be too long. But with respect to what you can do while you are waiting for the approval, there are two options. You can either pay the amounts that are provided by the sub-plan as of now, but employee must be informed that they could be forced to reimburse some of the amount to the EI in case that your sub-plan is finally not registered. Or what I suggest you do, considering that the waiting period should not be too long, is to wait to have the confirmation that everything is registered, and then you pay the sub-premium retroactively.
Thank you very much. I'm conscious of the time, and I just would like to make a few comments before we close. As I mentioned at the outset, perhaps some of those weren't on yet, this presentation is not available for download by the attendees via the WebEx structure, but you will receive a copy of it, anyone registered, in an email on Monday with the recording. So you get to hear our voices again. So please stand by for that. Also wanted to thank everybody for calling in. This is obviously a moving target, and Dentons is, as I say, has got global tracker information. There's a toolkit you can tap into as well. We're loading up stuff daily, so please check back, and we'll keep it as current as we possibly can. I wish you all safety and safety to your families, and we will have another webinar, I believe, next Friday, so stand by for notices of that, and thank you for your participation. This closes the webinar for today. Thank you all.